So we'll go to,
SJC-10618, Weber versus the Mass Appeals Court.
good morning,
Again.
Mr. Golder.
Good morning, Chief Justice Marshall. May it please the court, my name is Frederick T. Golder, and I'm appearing on behalf of Patricia A. Weber. This court was correct in deciding that this is an extraordinary case that deserves to be heard in order to correct three egregious errors that were committed by the appeals court. The appeals court committed two errors by failing to follow the law set down by this court and also failed to follow a statute, a Massachusetts statute. Before I get into the errors committed by the appeals court, very briefly, Ms. Weber, this is an employment discrimination case that has gone on for 17 years in two trials. The first trial, the trial judge applied the Blair burden of proof in discrimination cases, and in Blair, pretext only was sufficient, and the trial judge, in an 8-day trial with 10 or 12 witnesses and reams of documentary evidence, found that Ms. Weber was a victim of sex and sexual orientation discrimination. This court then modified the burden of proof standard by the Abramian decision. This court then remanded the case to the trial judge and said, you now have a new burden of proof, an Abramian burden of proof. Try it under that second court decision. And so the case was tried again using the Abramian decision. That essentially is that pretext alone is not sufficient, but it may permit the fact finder to infer discrimination. So the case was again tried before the trial judge, who again found that Ms. Weber was a victim of sex and sexual orientation discrimination. Now, what happened essentially, the appeals court disregarded the holding of this court in the Lipschitz case, which said, and I quote in the Lipschitz case, pretext for discrimination is an incorrect statement of the law. The three-judge panel that heard this appeal from the second trial said, essentially, in order to prevail, and I'm going to quote what the appeals court stated or held, the burden of establishing by a preponderance of the evidence that the articulated reason was not the real reason for the adverse action, but was a pretext for discrimination, contrary to the holding that this court made in Lipschitz. The second error they made was they disregarded the findings of fact and credibility determinations made by the trial judge. Disregarded it. And I submit that that's the second error. This court has held consistently that it's the trial judge that makes those determinations. The appeals court panel disregarded the findings of fact and the credibility determinations made.
Mr. Golder, isn't
Yes.
the real issue here not so much the substance and the merits, but the procedural posture of this? I mean, essentially, aren't we looking at your motion to vacate and submission of motion filed to all of the justices of the appeals court? Isn't that what we're looking at?
And that's, in your Chief Justice Marshall, that's the third error that the appeals court made. This three-judge panel first violated, when I say they disregarded the law that this court set down in two instances, and then when I brought the motion under Chapter 211A, Section 11, it requires all of the justices of the appeals court. This three-judge panel usurped the ability of those appeals court justices to exercise their discretion. That's the third error that the appeals court made. In other words, the motion was presented, all of the necessary copies were filed with the clerk, And there's a rule in the appeals court that the only people that get those motions are the three-judge panel that originally decided the motion, the appeals, thereby frustrating the intent and purpose of Section 11, which is to allow the majority of the justices. In order for that to happen, all of the justices have to have a copy of the motion to review. And that did not happen in this case, which brings us here. Have I answered your question?
What do you do with the word may?
I'm sorry?
May be reviewed and revised by a majority of the justices.
But unless they have it in front of them, there's no way they can review it. They've been deprived of that option. If all 25 justices at the time on the appeals court had reviewed it and said, we're not interested in doing anything to the appeals court panel, that would have been the end of the matter. But they never were given that opportunity. The three-judge panel that twice essentially disregarded decisions by this court, again disregarded the statute by not allowing all of the justices to exercise that discretion. That's exactly why I'm here. I submit that this court has the power to remedy those errors of law committed, not only in their improper interpretation of the cases that have been very clearly decided by this court, and you certainly have that discretion to send it back to the appeals court and say, okay, all 25 justices have to review this and exercise their discretion.
Excuse me.
Yes.
I'm just a little puzzled. Are you saying that every case that comes out of the appeals court could be referred to an review by all 25 judges?
They can decline to exercise it. It's pretty much like an en banc. This is similar to that. You present it. The court can decline to exercise their jurisdiction, but at least they have to have the ability to exercise it. And they can...
And in order to exercise it, you're saying they have to have a copy of the opinion? They have to read the opinion? And then they decide whether to accept it or not?
Well, Justice Ireland, I suppose theoretically they could read the decision or just simply decline to do it and say, look, we're not even going to look at it. But at least it has to be put before them. Whether they read it, I can't do anything about that. But at least to have it put before them to make that determination, yes. I also suggest that the better course of action, the more equitable course of action, given the 17 years and the 2 trials and the clear disregard of the law that has been set forth by this court, that the appropriate course of action would be to reverse the appeals court decision and to affirm the judgment of the trial court that was there for those days of trial. If you have no other questions, I'm going to rely on your reading of the brief. I think when you do, you'll see that the right course of action is to reverse the appeals court decision and to affirm the judgment of the trial court. Thank you very much.
Thank you, Mr. Golden. Good morning, Mr. Barnico.
Good morning, Your Honor. My name is Thomas Barnico, Assistant Attorney General, and I appear for the Respondent Appeals Court in this case. I also appeared for the appeals court in the county court, which considered the application for relief under General Laws, Chapter 211, Section 3. Relief was denied by Justice Spina, and we asked the court to affirm that judgment. The merits of the underlying controversy are not before the court. In fact, this court denied plaintiff's application for further appellate review of the panel decision in this case. What is before the court is the ruling by the appeals court regarding the handling of a petition for review by the full appeals court of a decision by a panel under the summary procedure of 128. The court reviews the ruling of Justice Spina for clear error of law or abuse of discretion. one of the considerations, of course, is whether there's another avenue by which the plaintiff could have preserved rights here. Of course, in applying for further appellate review, the full range of the merits questions all could have been brought to this court, and this court denied review. Closer question might be whether the order denying review by the full appeals court or the right to file a petition for such review was also subsumed or could have been subsumed within the application for further appellate review. I don't see why that couldn't be the case. Actions by the appeals court after a rescript, like the disposition of a petition for rehearing by the panel, could be folded within an application for further appellate review in the normal course.
Just say that again, Mr. Barnacle.
Well, it's certainly possible for a litigant who is aggrieved by something that happens in the appeals court after entry of rescript,
Right.
like the disposition of a panel rehearing petition, to fold that
Oh, I
within
see,
the
yeah.
application to you. In that respect, in any event, there was another avenue. The other ground to affirm Justice Spina on this would be to decide that the appeals court's orders correctly interpreted its own authority on the question here.
Well, it's not its own authority. I mean, it is its own authority, but it is a statute. And let me ask you this. It may or not be relevant to this case. First, this is very late, and so we hear on a 211.3, I mean, it's months later, and there may be procedural defects, but you have a statute that says, that upon a written order of a majority, the decision of a panel appeal court may be reviewed. I mean, that sounds in an en banc. As I understand Mr. Golder's complaint is that these materials were not even distributed to the justices of the appeals court. I don't know if that's established in the record, is it?
I think that's fair to say on this record, from particularly the communications, well, the orders of the panel, and then the communications from the first assistant clerk on behalf of the Chief Justice of the Appeals Court, I think made clear that this was not going to be circulated to the other 22
But isn't that,
justices.
I mean, to the extent that one can read 211A, Section 11, as similar to an en banc proceeding in the federal courts, it seems to me extraordinary that you don't even circulate it to the justices. There's no requirement that the justices grant en banc proceedings, right?
Right, although the position of the appeals court here is there's no right of the litigant to seek. So if that position is correct,
There's no right of litigant.
of a litigant to seek the en banc determination.
Because
so-
of the procedural defects.
No, because the appeals court, as expressed in the order of the panel and in the letter from the clerk, is that the en banc determination by the full appeals court is only a sua sponte power. There's no right conferred on a litigant to seek such review by the full 25-member.
There's no,
Court.
I mean, it's sort of analogous to there's no private right of action under this statute.
That's correct. And here's where I think the last portion of our brief could be helpful to the court, because, of course, at first glance, what is seems to be intended by the statute is an en banc determination similar to that's conducted by the Federal Court of Appeals. But our brief sets up...
But that is, to my understanding, never done except upon motion of a party.
That's where I was headed, Your Honor, is that prior to the 1960s amendments to the
Right.
Federal Rules of Appellate
Yeah.
Procedure, it was only an en banc right. It was only a sua sponte right on the Federal Court of Appeals' part. The amendment is made in the 1960s to expressly confer on a litigant the right to seek rehearing en banc. As we view the chronology, the appeals court is right, because in 1972, when our legislature created the appeals court, it chose language very similar to the older federal rule, a majority of the justices may, without any reference
But
to a right of a
the
litigant.
challenge was that, of course, then there were only 7 justices, 9. How many justices were on the court initially?
Initially, 7.
7. Now we have
I think it's 7.
25.
Well, I think that might be very much in the mind of the appeals court in taking the position it has.
I mean, it seems to me that what happens in the federal courts is that the litigant, in a big court is not limited to the luck of the draw of 3 justices. You've got a whole big court.
That's right, but my point simply that in construing the statutory language and
I
deciding
understand.
whether it's sua sponte or not. But the other, I should add that there's an element of the practice of the appeals court, as I understand it, that may bear on this
A
as well.
second panel review?
Yes, and that's because in a class of cases, the minority to be sure, but the appeals court justices beyond the panel are receiving the opinions prior to the issuance of a published opinion. So at least in that,
But this wasn't.
This
but
was
this was not. That's right.
So
And
the
that's
question is, why do some people have the benefit of that and not others?
the answer to that isn't on this record.
Okay.
And the panel, that practice isn't described, as I recall it in the orders here. And the fact that this is a summary disposition squares up the issue of why aren't these circulated as well. That's true. But as a matter of the practice, I think it does show that the plaintiff here is slightly overstating the case when he casts the case as one that's choking off the exercise of the right by the non-panel appeals court justices. The other portion of law that bears on this, I think, is the rehearing provision, which is, of course, Rule 27. That's what
Right.
allows a party to seek rehearing of this court or rehearing by a panel of the appeals court. And Rule 27C says, upon consideration of a petition for rehearing, a quorum or panel may, in writing, order their decision to be reviewed and revised by a majority of the justice of the court. And that's not limited to either the published or unpublished decisions of the appeals court. So, although that's not cited in a brief, it occurs to me that that is a further opportunity to at least alert a court to a particular kind of case that may warrant attention by the full appeals court. In any event, it shows, again, that the plaintiff's overstating about somehow being choked off from the rest of the appeals court in having the motion here denied. Of course, the sua sponte power, this gets to Justice Ireland's point, our position is this is a sua sponte power alone. It's only the full appeals court on its own motion that can convene itself to review. Well, we can presume that the full court is aware, in a general sense, of the 1-8 decisions and the entry of the corresponding orders in the reports in the normal course. So that is another check here. What was being intended, I think, is that the appeals court can act without a time limitation in a given case to address a panel decision in a 1-8 case in an extraordinary case. That's what this rule and this statute give them power to do, to correct an extraordinary situation in which a 1-8 power has been exercised, panel rehearing's been denied, and the only opportunity for revision of that order is by the full appeals court. So for those reasons, we think that there was another means by which the plaintiff could have raised this issue, and we also believe that the decision of the panel of the appeals court was correct in its interpretation of the en banc authority. Thank you.
Thank you, Mr. Barnico.
SJC-10573, Commonwealth First Class Bureau.
Thanks.
Is there any water left there, Mr. Steinfield?